The legislation now imposes duties on every parent who is applying for relief under this act. And those duties include exercising their responsibilities in the best interests of their child or their children, protecting children from conflict, where appropriate, trying to resolve their matters through family dispute resolution processes instead of through the court. So that could include mediation, collaborative family law, negotiation, arbitration. It requires parents to provide complete, accurate, and up-to-date information as they may be required. And that really helps with efficiency. We don't want the court to be clogged up with people attending again and again and again because they don't have the information that they need to be able to move their matter forward. And it also requires parents to comply with orders that may be made until they're no longer in effect.
Welcome to Access to Justice. I'm your host, Heather Malarick from Merrick Law, and I'm joined by my co-host, Evan Clark of Kahane Law. Hi, Evan. How are you doing this afternoon?
I'm good, Heather. Did you forget my name for a second?
I did, yeah. I'm a little feverish from getting the COVID vaccine yesterday, so you've got to forgive me any flub ups today.
Yeah, look, Heather is really not sharing the full story here, which is she was in a lot of pain last night because of that vaccine, and she's such a trooper. She's here, would not miss recording this podcast for the world. So good job, Heather. I'm feeling great. I did not get the vaccine last night. And it's a little cold though. It's snowy today, even though we're in April, but I'm over it.
Yeah. Spring in Edmonton, hey. And we also have our special guest here, Kim Mcdonald of Mcdonald Advisories. Hi, Kim. How are you?
Hi, Heather. I'm doing pretty good. Thanks for having me on today. I know before we jumped onto this podcast, I was complaining, as I always do, about my braces, and now I got the top ones on. And, I'm a little bit of an angry person right now, but I'm going to get over it and we can move on with the program. But for my compliance bit and our listeners who don't know me, my name's Kim Mcdonald. I'm a financial advisor at Mcdonald Advisory with Raymond James. And I am a guest on this panel today. And I really appreciate being invited. Thank you.
Wow, so our guest is really going to have a rough go of it today with Angry Kim.
We've got Angry Kim, feverish Heather, and Evan, who's cranky about the weather. So, well, I am very excited to introduce our guest today. We've got Riley Gallant joining us today. She's a partner at Latitude Family Law. She got her law degree from the University of Saskatchewan in 2008 and has been practicing family law since then for her entire career. So she started at Legal Aid, which is where she and I met, and continues to be a partner at Latitude Family Law. She is a litigator, a mediator, and a registered collaborative family lawyer, and has experience representing children in high conflict parenting matters. She's also a member of the Legal Aid roster and participates in the Independent Legal Advice for Survivors of Sexual Violence program administered by the Elizabeth Fry Society. I also happen to know that she's involved in many boards and associations and is such a generous donor of her time and knowledge and experience. I also happen to know that she is excellent dog trainer and has discovered a talent for watercolor during the pandemic. So welcome, Riley. We're so happy to have you. How's the pup doing today? Where have you got him contained while we're filming this?
Thank you, Heather, for that lovely introduction. My puppy is Ronan, and he's not currently here because he's quite demanding of my attention while I'm working from home. But thankfully, I have a cousin who lives in town, so sometimes he goes and hangs out with her. And she has school-age children who are now doing school from home for another stint of time. So he gets lots of good pets and snuggles over there with my cousin when he goes.
I think I saw you posted a bubble trick that you had taught him, and I was like just absolutely flabbergasted by that. Can you explain it a little bit?
Sure. So I can't take much credit for this. I'm doing a training program with him currently, and we were challenged to teach our dogs to blow bubbles in water upon request by the end of that 6-week program, kind of as homework. And so I take a bowl of water, I throw a treat in it, and he just naturally sticks his face in it and blows bubbles. So yeah, I can't take much credit for that. But dog training has been one of the things that I've been able to do during the pandemic. So what kind of started as a fun thing, it's getting a bit serious. We go to agility. He's a pretty bright little guy, and yeah, it's been really, really fun.
Yeah, he's a real sweetheart.
So I got what Heather's well-deserved lengthy introduction. I got a couple questions that stem from that. First of all, watercolors?
Yes.
She mentioned. So what's this? What is this she speaks of?
So I don't have any history of art. I didn't even take art classes in high school, but I think I saw it on Instagram. Somebody was watercoloring, and I thought, that seems relaxing. I'll give it a try. And I just found that I really kind of took to it. So most of what I learned was just following online tutorials. And yeah, it has been very relaxing. Really helps to focus on something else for a period of time when things are stressful. I recently did a watercolor family portrait of my nuclear family, my parents, my sister and I, and our various pets in front of the cabin at the lake, which blows my mind that I was able to pull that off. I mean, it's not great, but you can tell what it is. So yeah, I've really enjoyed that.
Yeah, that's my bar too. I've only watercolored once in my adult life that I can remember. And it's, if you can tell what it is, I feel like that's a success.
I've seen somebody say too, there's the hobby itself, and then there's buying things for the hobby as like a separate hobby. And that is very true for me. I've got quite the collection here of things that will I ever use? I don't know, but I enjoy purchasing them.
Nice. Now, the other question I had was this Elizabeth Fry Society legal aid thing that you're part of. Can you tell me about that? Because I'm not familiar with it, and it sounds awesome. So tell me about it.
Yeah, so it's two separate things. So I'm a roster lawyer with Legal Aid Alberta, which means that I'm able to take certificates for people who qualify for legal aid and do work for them under those certificates. That's how I do most of my representation of children work. And then the Elizabeth Fry Legal Advice for Survivors of Sexual Violence is a separate program. And the way that works is anybody who has been a survivor of sexual violence can contact Elizabeth Fry if they need some legal advice. It doesn't have to be in the realm of family law. It could be any type of legal issue. And if they qualify, then they can be set up with a lawyer to provide up to 4 hours of legal advice. And so that can look like whatever is most beneficial for a client. We don't become their lawyer of record and represent them, but we can just provide general information and advice. We can review documents. We could help with drafting, prepare calculations, anything like that. And so the Elizabeth Fry Society did kind of a call out for volunteer lawyers. And I say it's volunteer, but it's not technically, we do get paid. And they've done training with their lawyers, for example, on trauma-informed practice and that sort of thing. So every so often, I'll just get an email from the program saying, here's somebody that needs some assistance, and then I get to help them out in that capacity.
Wow, that sounds great. So for any lawyers that are listening that might want to get involved with that, how would they go about doing that?
There is a website, and I don't remember what it is off the top of my head, but I can certainly provide it to you if you want to add it in the notes. And then they have an administrator. They often have people with family law questions and often people with civil questions, but there might be other practice areas or other areas within Alberta where they have a greater need for volunteers. I don't have that information, but yeah, it would be certainly possible to contact them and say, I practice in this area. Is there a way that I can get involved?
Nice. Yeah, I just did a quick search for independent legal advice, Elizabeth Fry Society, and it came up. The website came up. So Awesome. Thanks for sharing that. That's not the main thing that you're here to talk about, but certainly is something important. So in a couple of years ago, the federal government decided it was high time that they make some changes to the Divorce Act. What is the Divorce Act? Let's start with that.
Yeah, sure. So the Divorce Act is federal legislation or federal law. And what I mean when I say federal is I mean that it applies in every province or province and territory across Canada. So some types of laws are specific to an individual province or territory, and federal ones apply across the board. And it originally came into effect in 1985. So that's, quite a while ago, and it hasn't undergone any significant updates or changes since that time. One exception is we had the introduction of the child support guidelines back in 1997. But other than that, it's been not really looked at since 1985. What the legislation does is it gives judges in the various superior level courts across this country with the authority to divorce people if people have applied to the court for a divorce, and the authority to make decisions regarding legal matters that are typically connected with a divorce. So if they're children, that could be a parenting order and, issues relating to how decisions are made with respect to children, and it can also relate to child support, and it can relate to spousal support. Oftentimes people separating will also have issues of property that they need to deal with, but the Divorce Act does not touch on property issues. Those types of issues are dealt with in provincial legislation.
And for our listeners, Riley, can you answer this question? It might be trite to ask this, but does it apply only for married people? Like, can common law, some people say they're common law married, can those people seek any relief, or can they apply for anything under the Divorce Act?
The Divorce Act does only apply to married people who are wanting to divorce. There is a different route to go, though, if somebody is common law, or as we say in Alberta, adult interdependent partners. That legislation is called the Family Law Act. And actually, people who are married but may not want to get divorced but still need to deal with some of these issues because they're separated, they can also utilize the Family Law Act.
Okay. So the Divorce Act is just dealing with formally, legally married people, but it applies all across Canada, and it's the same rules all across Canada for married people.
That's right.
Okay.
Processes might be a little bit different because each province or territory is allowed to make their own rules of court, is what we call them in Alberta. So you may see different processes. And of course, law is interpreted by judges. And so judges in different places may see things a little bit differently. So even though the overarching law is the same in each province and territory, the legal advice a lawyer might give on any specific circumstance could be slightly different province by province for those reasons.
Okay.
Yeah, I mean, I've even heard, I don't know if either of you, Heather or Riley, have heard this, but I've even heard judges between Calgary and Edmonton have their own, not biases, but like leanings for parenting, for example, that in Edmonton, they tend to lean more towards a 50-50 schedule wherever appropriate, whereas in Calgary, they don't lean quite so much in that direction. So if that's true, and I haven't been to court in Calgary and seen this in action, that's just only what I've heard, disclaimer. That's just an example of how judges who, can differ on their approach to the same piece of legislation.
Mm-hmm.
Yeah, and I think in Alberta, it was talked about previously moving to a unified family court where it's a set number of judges always dealing with family law matters. Some other provinces have a unified family court. And one of the benefits that can come if you do have a unified family court is a bit of enhanced consistency, because you have the same people consistently dealing with the same issues. People may not know this, but judges who are appointed to the Court of Queen's Bench, which is the court in Alberta that decides matters under the Divorce Act, they hear all sorts of things. So they could be in court one day dealing with a divorce, then they're dealing with a bankruptcy, then a criminal matter. So it's a very wide range of issues that they're deciding at any given time. And of course, judges are human and they have their own experience and perspective that is behind any decisions that they might be making.
And they might be coming to the bench from some other angle too. Maybe they were like a labor lawyer or something like that. So that's interesting. Okay, so go ahead, Evan. Yeah.
Move on from this. I just wanted to, just before we lose anybody that's not married, separating, that are adult interdependent partners, can you just talk a little bit about how the Family Law Act compares to the Divorce Act for key things like parenting, child support, this type of thing?
Yeah, that's a great question, and something I was hoping that I would have the opportunity to talk about, because the changes that have been made to the Divorce Act are not completely out of the blue for Albertans, because we have a relatively recent Family Law Act that is quite similar in a lot of aspects to this new amended Divorce Act. Some provinces, their provincial legislation touching on family law was more dated or quite different, and so they now will have a big adjustment to make when it comes to operating under the amended Divorce Act. But in Alberta, there are a lot of similarities to how we were already functioning when utilizing the Family Law Act and how we'll now be functioning using the Divorce Act.
Okay, so I guess that begs the question, what has changed? What's new in this new Divorce Act?
Yeah, so there are a whole host of changes, and I'm going to focus on the most significant changes, or the changes that I think would be of most interest to the most amount of people. Basically, the federal government was looking to update the Divorce Act with a few goals in mind. I think the primary goal was to better focus on the best interests of the child as a primary consideration behind the Divorce Act. The previous version already said that when judges are making decisions about parenting time or children, we used to say custody and access, they should be doing that based on what's in the best interest of the child. But now the amended version includes that in various places and expands on that. It gives the court a bit more direction on what they should be thinking about when being asked to make those types of decisions that impact children. And there's also a focus on addressing family violence. That's an overarching goal of these amendments. Some of the updates to the child support portions that I probably won't touch on very much in this conversation are meant to try to address issues of poverty as well, and generally to try to make the family justice system more accessible and more efficient. So I know that's a particular interest to those of you probably listening to this podcast and hosting this podcast. So some of the changes that are significant is the legislation now imposes duties on every parent who is applying for relief under this act. And those duties include exercising their responsibilities in the best interests of their child or their children, protecting children from conflict, where appropriate, trying to resolve their matters through family dispute resolution processes instead of through the court. So that could include mediation, collaborative family law, negotiation, arbitration. It requires parents to provide complete, accurate, and up-to-date information as they may be required. And that really helps with efficiency. We don't want the court to be clogged up with people attending again and again and again because they don't have the information that they need to be able to move their matter forward. And it also requires parents to comply with orders that may be made until they're no longer in effect. There's also some additional duties on lawyers who are representing people under this law. And one of those additional duties is to encourage any clients that we might be advising to use family dispute resolution options, again, unless it would be clearly inappropriate to do so. And we're also required to inform clients about family justice services options that might assist them. That's already existed in the Family Law Act in Alberta, so lawyers should hopefully be used to having those conversations with clients already. And we in fact have to certify when we're filing a claim with the court that we have done that. So those are some kind of general goals and changes that have been made. Getting into some more specific changes, we now talk about parenting in terms of parenting time. and decision-making responsibilities instead of talking about custody and access. And this change was brought in because it was seen as being more focused on relationships that children have with their caregivers instead of, I think, the legal kind of definition of the role that a parent is taking. So that's a bit of a shift, and again, that's in line with what we were already doing under the Family Law Act. And the Divorce Act also tells courts what to consider when they're trying to decide what is in the best interest of the child. There's a whole list of things. I can go through some of them if you think that might be of interest. But one of the important updates is specifically considering family violence and the impact on any family violence that may have occurred on the ability and willingness of a person who may have engaged in family violence to care for and meet the needs of the children. So that's a pretty significant inclusion there.
So what was it before? Why would that be so significant for people who haven't been involved in divorce before?
So before the Divorce Act just didn't really clarify what judges should be looking at when deciding what is in the best interest of the child. It just didn't say. It just said consider what's in the best interest of the child. In Alberta, our provincial legislation, the Family Law Act, already had a list of considerations. So we were quite used to addressing those considerations when in court. And of course, judges in the Court of Queen's Bench deal with both pieces of law. So they were already used to thinking that way. But this provides some consistency across the province, or across the country rather, just in case there might have been some places where it wasn't specified, and just makes it clear that under this piece of law as well, this is what we should be looking at.
Yeah, I think that's such a good point, because I think just the judges having a list, because like you mentioned before, Riley, or was it Heather? One of you mentioned that their judges can be appointed from that practiced in any area of practice, and now they're a judge. And so providing them with legislation that's really clear, instead of, you know, it just being out there in the common law realm and some other decisions that they'd have to know about first, hopefully will help with getting more uniform decisions about what's in the best interest of the child. I had a question though. I have a couple questions from what you just, your introduction to these changes. The first one I wanted to ask about was, okay, so people that are making a claim under this act now have a duty, you mentioned, and including a duty to protect children from the negative effects of going through a divorce and putting their needs first. So my question is, I think people would be tempted to think like, don't parents already have that duty? And so, okay, it's good to have this in there, but like, what does that exactly do? And it's okay if you don't have like a great answer for this, because it's kind of, I'm not sure exactly what putting that duty in does, besides people have to sign something that they didn't have to sign before. But like, is there anything more to it, Riley?
I mean, I suppose lawyers have to confirm that they've told clients that they have that duty. And so my hope would be that would prompt a bit of a conversation between the lawyer and the client about what that really means. And certainly I would hope that most people would strive to do that anyway. But oftentimes when couples separate and it can be chaotic, it can feel like a time of crisis, people aren't always making their best decisions, and they may not be their best self or their best parent at that given time. So I think it provides an opportunity for the parent to pause and really think about that, and maybe have a conversation with their lawyer, or consider what exposure to conflict will do potentially to their child. And there's a lot of research, and you may have touched on this before in a previous episode, or maybe you're planning to on a future episode, but there's a lot of research available about the significant negative impact that exposure to high conflict for prolonged periods has on children. And it can create an environment of toxic stress and can actually even impact brain development. So these are serious, potentially long-term consequences. So I think it's an attempt to just remind parents to keep their children focus first, try their best to resolve things outside of court as quickly as possible, to alleviate any of that conflict and just kind of keep their priorities where they should be.
Does it serve a dual purpose as well? Just having parents focus on a clear issue. So if they have a focus, then they can drive decisions that way and get things moving. Is that part of it? Is there an underlying piece to that?
Yeah, there may be. I think if there's just something that you can kind of always return to when you're making decisions throughout the process, that's probably helpful.
Yeah. Riley, when you mentioned high conflict situations, does that encompass, that would encompass situations of family violence, but is there a broader definition of that, of high conflict? Like, are we talking just about situations where there's family violence, or?
Yeah, no, we wouldn't be talking about situations just where there's family violence. And high conflict isn't something that's defined by the Divorce Act, but certainly in my experience as a family law lawyer, I can kind of give some examples of what that might look like or what the court might be concerned about if they were presented with it. So that can be things like just arguing in front of the children, even if it doesn't reach the level of family violence, but there's that tension and argument swirling around the children. It can include things like speaking negatively about the other parent in front of the children so that they're hearing that sort of thing. It can include discussing court about around the children, causing children to be fearful of what's happening in that regard. Causing children to feel like they are responsible for the outcome or that they're being forced to choose a parent. Those types of things can happen and can be very damaging to children. So, and sometimes people don't even realize they're doing it. It's not intentional. And, they do have really good intentions when it comes to parenting their children. They may just not be mindful of the impact their behavior could be having.
Okay. Yeah. Thanks for clarifying that and explaining the difference or the overlap between those two kind of situations.
Another thing that this amended version of the Divorce Act does is allows judges to include a parenting plan that parents might make themselves, either just together or utilizing an alternate dispute resolution process like we've talked about to an order. And that really encourages parents to take responsibility and come up with a plan that is going to work for them. Parents know their children best. They're very likely to know what's going to work best for their children themselves and their families. Oftentimes when judges are making decisions, depending on what type of court process is occurring at any given time, they may have very limited information about the parents and the children and be asked to make some pretty consequential decisions. So that's something that's new in this version. And it again just kind of goes back to encouraging resolution outside of court and allowing parents to make those decisions. The exception is the amended legislation says that a court doesn't have to endorse a parenting plan if a judge feels like it's not in the best interests of the child. So judges do still have that kind of overarching authority to make sure that everything sounds okay when they're being asked to make those orders.
So what's the difference between a parenting plan and parenting time or a parenting schedule that might go into the order?
So a parenting plan could include a parenting schedule. It could also include a decision about how the parents will make decisions for their children. And it can include any other term or condition that a parent might want to address in their parenting plan. And essentially what they're doing is they're creating their own plan, and then a judge is basically turning that plan into a court order and saying, yes, okay, this is now what's going to happen. If there is no parenting plan, those same types of issues can be dealt with in a court order. So a court order can say where the children are going to live and when they're going to go back and forth between two households. It can say who is responsible for making decisions for a child. That could be one parent is completely responsible to make all decisions. Maybe they share responsibility, or maybe one parent is responsible for certain types of decisions, but the other parent is responsible for other types of decisions. It can include information about how the parents will communicate with one another. So if conflict often happens when they communicate in person, but they do great over the phone or by email, it can specify that. It can specify ways to address any concerns that a parent might have. So sometimes the parenting order might say that children won't be exposed to drug or alcohol use, for example. It can say if a parent needs to be supervised for a period of time. And parenting orders can be short-term or long-term. They don't have to last, indefinitely. You can build in a date when they're going to be looked at again. If it's possible to make an agreement, say for the next 6 months or the next year, but you have trouble getting beyond that, you can always kind of specify a return date. And so they really can be as creative as possible to address the needs of the family. And where people are working on that together, they can be much more creative than usually a judge can be. So that's another real positive of parents trying to get together to work those details out themselves.
Right. They know their family best and kind of what might work for them or their children ultimately.
Is there a kit? Like, I'm thinking, okay, well, people are just brand new to divorce. And they're like, I got to come up with this plan with my spouse. It's better if we do it together. Is there like a will kit type of idea out there to put this together?
Yes, absolutely. There are resources online, and that's an excellent point, Kim, because oftentimes people will come and say, I know I need a parenting plan, but I don't even know what to consider. So an example would be, do you always agree on how to share a holiday like Christmas, or do you need to specify it? What happens if one of you wants to travel outside of Canada? What's going to happen there? Who's going to hold the passport? All sorts of details that people might not think about. So the federal government, again, does have a resource on the website that asks those questions and prompts that consideration and gives some ideas, I think. I'm fairly certain that the Canadian Bar Association family section also has a toolkit about parenting plans. So those are a couple of resources that I'm aware of. And there's also different organizations, for example, of collaborative lawyers that will sometimes have resources. So I've done that research for clients before to provide resources, and sometimes found things from even the United States that would still be applicable for people to be working through, because it's really just prompting questions that they might want to consider. So even just a Google can be quite helpful.
Kind of to give you that list of topics that you might want to think of ahead of time and discuss and make decisions on.
Yeah, and I like it's always best to keep it as simple as your situation will allow. And what I mean by that is, where people have good communication, you probably don't need or want a really detailed plan, just want guidelines to help you. But where agreeing on stuff is a real challenge, it's better to be very specific so that you both have something you can rely on so that it's not in conflict all the time.
And it can be helpful to have a bit of a default too. So generally a parenting plan or even a parenting order will include some ability for parents to agree to something different if they both agree. That might be difficult if there's a history of it being unclear whether they've agreed or not. So we have to be cautious with that. But typically, if you've agreed to share a holiday one way and you both want to do it another way, that's not going to be a problem. And it can be helpful just to have something to default to, so that just in case that conflict arises, you have something that you can fall back on. And it's not always possible to access the court. So of course we're in the middle of a pandemic, and that has created issues with court access that are being worked through. But even pre-pandemic, for example, if you thought that you had an agreement regarding holiday parenting time, and suddenly it's December 15th and you find out that actually you don't, and you have no idea where your kids are going to celebrate Christmas Eve, Christmas Day, and Boxing Day, you might have lost your opportunity to get into court, and it's just not going to be possible. So that's something, that's beneficial again with resolving disputes outside of court. You're not limited by the court schedule, and something to keep in mind when parents are trying to build parenting plans.
So you're saying, like, you might have a default schedule in your parenting plan that dad's got the kids in even years, mom's got the kids in odd years. You can move away from that. But if there's no agreement, then we know we've got the schedule there set out, and we know what's happening if we can't agree.
That's right.
Yeah, I've seen that work pretty well for folks in the past.
Has the
Got it.
divorce? Oh, sorry. Go ahead, Evan.
I've got a question for either Heather or Riley. One thing that will commonly be seen in a parenting order or divorce judgment that contains terms about parenting is that it'll say something to the effect of primary parenting with this person, or something like, or it might even be a certain schedule, and then the other person will have a certain schedule or not, and then it'll be, you know, generous access or generous parenting time. And I think it's very common that that generous other time that as parties agree on is never agreed on, and the other person never gets any additional parenting time. If someone finds themselves, or what can somebody do to prevent themselves from ending up in that kind of a situation where, oh, this term of reasonable and generous parenting time sounds great, but it might not ever happen if it's a hard time for them to agree on anything.
Do you want to, I feel like I've been talking a lot, Heather. Do you want to answer that?
You're the guest though, Riley.
What's up?
You get to talk as much as you want. You're the guest.
I mean, I can take a stab at it, and Riley can say what she would do too, because I think there's probably different answers depending on the situation. But Riley alluded to earlier that parenting orders are not forever orders. So if something's not working, they can always be brought back into court for further clarification, or to add in specifics of time. I mean, I guess I feel like it's pretty fact and case dependent, but would that person want to know that they've got a minimum amount of time with their children? Would they, you know, do they want a set schedule? Do they want to put a default schedule in there, but maybe be able to agree from it? So those are some of the things I'd probably be thinking about.
Yeah, I agree. I would say it takes a very high level of trust between parents to have a schedule that is that flexible in an order. And if sometimes people have complicated work schedules, and so it might be impossible to say, I'm always going to have parenting time Wednesday to Sunday. But you might be able to say, I'm going to have parenting time 3 overnights out of the week. And sometimes we can even get as detailed as saying, you know, one parent will provide their work schedule by X date. So maybe 5 days prior to the first of the month, the work schedule goes, the parties have so long to figure it out. Sometimes if it's a holiday issue, for example, trying to figure out how to divide up a summer, one parent might get the first choice in odd numbered years, and another parent might get the first choice in even numbered years. So there's lots of things that family lawyers have kind of experienced, you know, over the length of time that we've practiced, problem solved around, and can often present as options that might work for families based on what we've seen work for other people.
Those are both good answers. I think I think what I'm picking up is if you already know that it's tough to agree, then maybe just have something a little more specific as to what you're hoping for, even if you can't be, it's every X day. Yeah, I think that sounds good. Sorry, Kim, I cut you off twice. I apologize. I don't want to get on Angry Kim's bad side.
That's right. You better keep it real over there, Evan, in your little corner box. Actually, I was happy to hear you interject because I wanted to take the conversation in just a slightly different way. So I was happy that you got your question out on parenting. So what I've been thinking about a lot lately is underrepresented people in this world. So LGBTQ+, our Native population, and I'm curious if there has been a discussion in the Divorce Act on different cultures and how they address that in the court system. Has that been brought up in that act? Are these people being represented?
There is, so under the best interest of the child factors that are now included, some of those types of elements of a child's circumstances are addressed, maybe not explicitly, but you can see them in there. So for example, I'm just reading my notes because I want to get the language specific and correct. One of the things that a court would be asked to look at is a child's cultural, linguistic, religious, spiritual upbringing and heritage, including Indigenous upbringing and heritage. So that is specifically listed in the best interest factor. There isn't anything specific to addressing LGBTQ plus family members, but I can say this is specific to Alberta. Our divorce forms were recently changed to be more gender neutral. And so instead of saying, there were some forms that said husband and wife, but of course you might not have a husband and wife, and those were changed to say spouse one and spouse two. So that's not specifically tied to the Divorce Act, but I think it shows that, you know, courts are attempting to be mindful of those sorts of issues and try to address them when they, you know, are apparent.
Great.
I guess I would add to that the increased stress on best interest of the child, of the children, I think kind of goes to that as well, in that you know, whatever's in their best interest is what should be paramount, not what's most convenient for the parents.
Yeah, and there's no presumptions either. And so what that means is that there is no starting point. So, you know, if we go back years and years and years, there used to be this idea called the tender years doctrine, which was that it was this assumption that young children are better off with moms. That was done away with a long time ago. The previous version of the Divorce Act had something called a maximum contact principle, and that was a bit of a misnomer because sometimes people would interpret that as it's in the best interest of a child to have maximum contact with both parents, and that means shared parenting. But in fact, what the legislation said is it's that kids should have maximum contact with each parent as is consistent with their best interests. So that might be shared parenting, that might not be. And the Amended Divorce Act has taken away that maximum contact language. It's very clear that there is no presumption. There is no starting point. It's not presumed that shared parenting is best. It's not presumed that parenting time with one parent is best. Similarly with decision-making, usually parents will have joint responsibility to make decisions unless there's some reason why that would not be appropriate. But that's not, the Divorce Act doesn't say that. It's just kind of what we do. It's very clear there are no presumptions. It always is supposed to come back to what is best for any particular child in their particular circumstances.
The Divorce Act sounds so fair. Like all three of you are lawyers. When it came out and you read it line by line and went through this thing, was your interpretation that they're on the right track, that changes were made in the best interest of people? I'm curious to hear all of your opinions on that.
Well, I guess I'll go first. We haven't got yet to one of the things that I think is really important that I hope Riley will talk about, which is to do with relocating, moving, and notice around that. Well, I don't want any spoilers. I don't want to spoil Riley's bombshell there. So, but the from what we've talked about already, yeah, and maybe partly because of the Family Law Act that we have in place in Alberta, and because the language that changed, one of the big changes that Riley already talked about was going from talking about custody and access to parenting time and decision-making authority. And that's more consistent with what our Family Law Act says. And the thing that I'm so grateful they changed it is because people would come and talk about, when you hear custody, normal people just think that means parenting time as well as decision-making authority, when in reality it didn't really. It's really, full custody meant more than just like you have parenting time all the time. It means the other parent can't make any decisions about that child's life. And so yes, that change I think was really important to make it a little bit more easy for everybody to understand, instead of every time you hear custody and then the lawyer has to explain that that's like basically a term of art. So that was one thing that stuck out to me that I was glad that they changed. What do you think, Heather?
Yeah, and I think it gives some finer tools, I hope, for courts and for lawyers to use and look at. So like Riley said, each case should be looked at individually and looking through all the factors and deciding whether decision-making might best go to one of the parents for whatever reason that might be in the best interest of the child, and always keeping the child in the middle of that analysis. So I'm going to be very curious, I guess, to see as these new cases wind their way through the courts, if lawyers and judges stick with our old habits, or if we do, get out of the maximum contact sort of thought presumption that means shared parenting, or if we do really start looking at things in a more nuanced way and looking at individual families. So I think that's a really good thing, I think, but I'm very curious to see how it's going to get interpreted by lawyers and judges.
Yeah, and just to add again, like language change may not seem like a big deal because the substance didn't really change, the language changed, but I think it's important because the language reflects a paradigm shift. It reflects, like saying access, well, that's talking about it from the parent's perspective. Calling it, parenting time, that takes into more account of it's supposed to be focused on the child. So I think that our paradigm as a family law bar, both and a bench, so the judges and the lawyers, I think it's slowly been shifting over time to a better place. So I'm hopeful that it'll keep going.
Yeah, and from my perspective, I was very happy with the changes in the legislation for the same reasons kind of touched on by Evan and Heather. One of the things that concerns me though is still that accessing the court is so difficult. So while it's wonderful that we now have better attention paid to family violence and how that can impact children, if you can't get the issue before a judge for months, or you don't have enough court time to prove what you're trying to prove in relation to family violence that may have occurred, that can still be very limiting as well. So just as an example, at times people have disputes over whether or not there should be a restraining order or various types of restraining orders that a court can grant. And when there's conflict over evidence, there should really be a hearing so that the judge can hear from both parties and make a decision. But sometimes hearings don't happen for quite a while, which can be quite prejudicial to one or both parties. And sometimes when they do happen, they're so short, a judge is making a decision without really having a ton of time to consider everything. So it's great in theory, and I hope we'll have good results as the court starts dealing with it, but there's still that challenge of an overwhelmed court system, everyone doing their best to get matters through as quickly as possible, but those limits. And so like I often talk with clients, if you need to bring an initial application for something. So say you've just separated and you have no agreement on parenting time and somebody wants to request a parenting order from the court. Usually the first stop is going to be what we call regular chambers, and judges make that decision not having spoken to either parent. It's based on what their lawyers say, based on what clients have put in a written document. We call it an affidavit. Each lawyer is supposed to have about 10 minutes. And then a decision is made, and that decision can be hugely consequential. So there's still that challenge.
It's supposed to be even less than that. It's supposed to be 20 minutes for both sides to speak and the judge to make a decision. So yeah, that's a huge problem, right? Because that's not enough time to really get into details. That can only be for simple things, and that's if you need to have something more complicated, then what does that look like?
Yeah, and judges have There's rules of court, there's rules of evidence that they need to follow. And this is all about protecting procedural fairness for people, which means that the process that they're using to get a decision over their matter is supposed to be fair to both of them. Something to keep in mind is there are alternate processes outside of court that are kind of like court, but are not court. That's arbitration, and that's one of the things that's referenced in the revised, the Amended Divorce Act as an option. And so if people are interested, and you might have talked about this already or are going to talk about it, but it's essentially figuring out their own process for how someone else will help them by making the decision, but not necessarily in court. So somebody accessing that option can choose a timeline because they're not stuck with the court's timeline, and they can choose process, how much information is going to be provided by who and what format, that sort of thing.
Yeah, that's episode 4 with Catherine Spafford, so you can go check that one out. She talked all about arbitration. What does the Divorce Act say about arbitration? Does it just mention in passing, or does it say anything else?
So it lists arbitration as one of the options that that people should be made aware of. I can't think of, does it say anything else? I can't think of anything else specific to arbitration.
No, I was cheating, right? I was just relying on you to know the answer.
Is there something that I missed?
No.
Okay, I can't think of anything more detailed than that.
But yeah, those things that are listed are not just nothing, right? They're real, very real alternatives to trying to go through the court system. And that's part of why we started this podcast in the first place, is what you're talking about is an access to justice problem. And it's very real. We see it all the time where people just cannot afford to get a lawyer to help them, and operating in Queen's Bench, which is the level of court that divorce stuff is taken care of in, that's not really an intuitive process and can be overwhelming for people. So alternatives can be very helpful and much easier to navigate.
That's right.
How important is it for people to read the Divorce Act if they're thinking about divorce, if they're in it at the moment, and the Family Law Act? Are these documents that lawyers say to their clients, you got to go read all of these details on both these documents so you can get up to speed? Is that like the perfect client? Is that something people would benefit from? I'm curious where those documents fit in, or are they just for lawyers?
Yeah, that's a great question, Kim. I don't recommend that my clients go out and read the legislation. It is all available online, so if somebody was interested in reading it, they certainly could look through it. I think as lawyers, we're very used to reading legislation, so we're used to how it's set up. There's always definitions, we're used to the language that is used, but I can think back to when I started law school and was reading legislation for the first time, and it was a little bit overwhelming. So I don't think that is probably the best way for most people to get information, but certainly if somebody's inclined to do the reading themselves, it's available and they could do it. But there are a ton of resources that summarize the legislation that are publicly available. And I think people would be much better off starting there. And I suppose if they're interested, going a little bit further. Because people do have different sometimes they want to know every single thing. Sometimes they're happy for their lawyer to handle it. But there are definitely resources that will summarize. There's public legal education resources that will summarize. So that would be the better starting point, I would think.
Yeah, and it's not like we lawyers want to keep the laws secret from our clients. Of course not. But what we want to avoid is people misunderstanding the legislation. And also there's two parts to it. There's the legislation and there's how it's interpreted. And that is generally carried out in the case law. And it's our job as lawyers to be familiar with that and how it applies and and like what it means in everyday solutions. So anybody can read them, and it's not by all means read them, and they're better now today than they were 50 years ago. There's some horrendous legislation out there that's still on the books where you read it and you're like, what are they trying to say here? So, I mean, the Divorce Act is much better written than, old legislation. But we always, it's our job as lawyers to help interpret that so that we can, help you understand what it means, as opposed to trying to go it on your own.
Yeah, there's definitely an effort towards plain language and accessibility and people being able to have the opportunity to either represent themselves or to understand the concepts though as well. So I'm thinking of the most recent divorce forms that came out in Alberta. The huge emphasis on those forms is so that anybody could pull them up on their computer and fill them out, and the court would be provided with all the information that it needs in order to grant a divorce. So certainly the legislators have that in mind and are thinking about that all the time. And I think that one of the goals of the legislation is also to keep families out of court, recognizing that by the time you've gotten to court, you're probably in a fairly high conflict situation, which is recognized to not be good for children and for the litigants, for the people that are involved. So I think probably one of the goals is to try and help with that backlog and keep people out of court where court isn't the best or most appropriate option for them. And that's probably why arbitration was listed, collaborative family law, all of those other mediation, all those other options.
So Riley, what other changes do you got for us?
Do you want to talk about relocation?
You sure do.
Okay, so the Divorce Act amended version now provides some guidance about how the court should treat a situation when one parent wants to move away and probably take the children with them, or even if they're just moving. And so the reason why this is important is we are seeing more and more of these types of applications coming before the court. And the Divorce Act didn't previously specify how those should be handled. And so we weren't completely without guidance. Judges create case law when they make decisions, and that provided us with some indication of how judges would treat these sorts of cases. And we had some guidance from the Supreme Court of Canada that would then apply throughout Canada. And we're following kind of that system, but it was still very difficult to manage those types of applications. And so what the court has tried to do is provide a little bit more guidance about how that should happen. So they've addressed a few things. They've addressed what relocation is. So when it is considered significant enough of a change that this process would be triggered, and what needs to happen if it's not, and then a process. So describing, what parties need to do, and then what the court will do if the court is being asked to make a decision. So I can run through that. So what is considered a relocation is a move that would have a significant impact on the child's relationship with another parent or somebody who has contact with them. So for example, if two parents live in the same neighborhood and one's just moving a neighborhood over, maybe that's not a big deal. But if two parents live in the same neighborhood and suddenly the other one's moving to Vancouver, that's going to be a big deal because parenting isn't going to be able to look the same in light of that move. So if it's not significant and it's just a change of residence, notice of the move is still to be provided. So the person who's changing residences would be required to provide notice of that change in writing, state the date that they're moving, and provide their new address and contact information. So usually people would do that, not always, but now it's clear that that's something that is supposed to be done. If it is a significant move, people may have heard this referred to as a mobility matter. The Amended Divorce Act calls it relocation, but oftentimes in Alberta, at least, we're used to talking about it in terms of mobility. The process there is that the person who intends to relocate has to notify whoever they're required to notify. So typically it's going to be the other parent at least 60 days before they're proposing to move. They have to give information like the date that they want to move, where they're going, contact information, new address. And they also have to provide what they're proposing in terms of the new parenting schedule. So where people live far apart, that might be, maximizing the amount of time the child spends with the other parent during the summer or school breaks, that sort of thing. And how decisions would be made also for children in light of that move. And once the person who is not moving receives notice, then they have an obligation to object to the relocation within 30 days if they're not okay with the move. And if they're not okay with the move, complete a form that provides some information that's set out in the Divorce Act, like their reasons for objecting and what they think of the proposal in terms of the parenting time. If there is an objection and the court is being asked to make that decision, what the Amended Divorce Act says is that in determining that, they have to consider that list of best interests of the child factors that I didn't go through in detail, but that we spoke about earlier, and some additional factors. So they are required to consider the reason that the parent is wanting to relocate, the impact the relocation would have on the child, the amount of time the child spent with each parent, and the level of involvement the parents had in the child's life, whether the parent who's intending to move gave the proper notice and has followed previous court orders, the existence of any agreement or court order that might specify a geographical area that the child is supposed to live in, the reasonableness of the proposal for the other parent's parenting time, and whether a person who has parenting time or decision-making complied with obligations that they were previously supposed to comply with, and whether they're likely to comply in future. So an example there would be if somebody has a history of breaching court orders, not letting the other parent see the child, that's probably going to be a concern to the court. Something that the court is not to consider is whether or not the person who's requesting to move would stay put if the court didn't allow them to move. And so that was present in the case law previously, and it was referred to as a double bind. You can't really put a parent in that position because they're probably going to say, yeah, I wouldn't move. And then it kind of gives the court an out to say, well, then you don't go. So the way these are treated is parents are able to be mobile, right? Like we have the ability to move wherever we want within Canada. The issue is really whether kids go when the parent goes. So it's an assumption that if a parent says they're going to move, they're moving, it's treated as such. And then the question just becomes, is the child going to go, or is the child going to stay with the other parent? And it also speaks to who has the burden of proving what is in the child's best interest. So what it says is if the parents had substantially equal amounts of parenting time, the parent who wants to move has to prove that that move would be in the child's best interest. If the parent who moves had the vast majority of the parenting time, so it wasn't shared or close to shared, it was a primary caregiver situation, and wants to move, then the other parent has a burden of proving that the move is not in the best interest of the child. And if there was no parenting order, maybe a new separation, nothing was ever granted by the court, or there was no agreement, then both parties have the burden of proving to the court what is in the best interest of the child in that situation. And this is a little bit interesting in that what the court has legislated, what the government has legislated is somewhat different than how the court was previously treating mobility applications. So previously, courts were instructed, or case law said that judges shouldn't consider the reason behind a parent's move unless it was relevant to their ability to meet the needs of the child. But the government has said, no, actually, we do want judges to consider the reason for the parent's move because it could be relevant to the best interest of the child. So that's a little bit of a departure there. The overall hope is that this will bring some consistency to these decisions. And if decisions are more consistent, hopefully lawyers are better able to advise clients about potential outcomes. And if that's easier to predict, it may prevent disputed court hearings because people will have a better idea of whether their application is likely to be successful or not. So I think that's a significant goal behind these changes.
Yeah, I'm not one that's like super that loves government regulation in general. I tend to be more libertarian leaning, but from my experience as a family lawyer, I'm very happy about these changes, this forcing that the court is doing, forcing the parents that are thinking about moving to provide notice, because really, obviously, you should be providing notice and enough notice for something to happen, or before for there to be a dialogue before you just move. And so I think it's a great thing, because I think before this, if I understand, recollect correctly, Riley, and you can correct me if I'm wrong or share some more insight on this, but before these new changes came into effect, there was zero responsibility, or there was nothing that they had to do if a parent wanted to move with the children. They didn't have to notify anybody. They could just move and hope the other person didn't bring a court application. And so obviously could you imagine if you were not the primary parent, you were exercising some parenting time, maybe every other weekend or something like that, and then one day you go to pick up the kids and they're gone? I mean, obviously hopefully that wouldn't happen, but you know, the equivalent of like, oh yeah, we're moving next week.
Yeah, and that certainly happens. I mean, sometimes parents find out about a move after the fact. You know, they've had their parenting time one weekend, and then their next weekend is up and they get a call that says, sorry, we're in Newfoundland, or, you know, wherever they might be. And you're right. I mean, if there's a court order in place, people are obligated to follow that court order. And obviously, if you're moving across the country, you probably can't follow that court order anymore. And so there would be a positive obligation to apply to vary that court order before you move, but that does not always happen, or did not always happen. And even if there's not a court order, yeah, people could just pick up and move. The court would see that as something that we often call a self-help remedy, which is kind of, I've done the thing I wanted because I didn't know if the court would allow me to. Too bad it's done. Let the chips fall where they may. Are you really going to, you know, pull these kids out of school and make them move back, or what have you? And that was frowned upon, to be sure. Self-help remedies are discouraged, but sometimes they would still happen, and a move could create quite a bit of chaos. And something else that could also happen is maybe somebody moves and files a court application in the new province, and there's something happening in the old province. So yeah, it can get quite complicated and quite messy. So it's certainly helpful to have, you know, some expectations and guidelines regarding how these will be handled.
Riley, I'm thinking out loud about the family violence situations, and you mentioned that there were some notice provisions about, even if you're just moving, for instance, from one address to another, are there any exceptions built into the process for those kinds of situations? Like, what if you've got someone who doesn't want their former spouse to know where they're living for safety reasons or other reasons?
Yes, there is an exception for exactly that reason. So the Amended Divorce Act says that if, for example, in a situation of family violence, it's possible to apply for permission not to share an address, and that application can be made on a without notice basis as well, which would mean that you wouldn't necessarily have to provide your spouse with prior notice that you're seeking to do that. So I think that's a good example of one of the ways that the government has tried to be mindful and really turn their mind to how family violence can be impactful for people and provide those kind of elements or options that may be necessary.
Okay, thanks. Kim, I thought you had something to say, Kim, but
I'm on the edge of my seat waiting to hear about all the changes. Like, I imagine there's quite a number of these things.
Another thing that, I mean, it's not a huge deal because we already had this in, it was already possible under the Divorce Act, and we certainly have it under the Family Law Act, but there's now provisions for specific contact orders to be made under the Divorce Act. And so that's language we're very used to dealing with in Alberta under the Family Law Act. But what that is it allows the court to grant somebody who is not a parent of the children, or in the case under the Divorce Act, weren't spouses, the ability to have contact with a child. So sometimes people will talk about grandparent rights, and oftentimes that's the sort of thing that they're talking about. That again is a misnomer. Grandparents don't have rights to their grandchildren because every decision that a court makes regarding people having contact with a child is based on the best interests of the child. So if it's in the best interest of the child, they can make an order to provide a grandparent or, you know, an aunt or whomever with contact with the child. But if it's not in the best interest of the child, there's no requirement. So that is a bit of an update as well, that there's now specific provision for contact, and that requires leave of the court. So leave of the court means that there's an additional hurdle that somebody has to get over before they can charge forward with a court application seeking contact. A judge needs to be satisfied kind of at an initial stage that that's something that should be allowed to proceed before the process gets any further down the line.
That's interesting. I haven't had too many of those kinds of applications in my career. How about you, Evan and Riley? Have you come across many contact applications?
A couple. They're tough. And I was talking to another friend, a lawyer friend, who is representing it's a tough situation because he's representing a parent whose spouse died, and the spouse's, my friend's client's in-laws are trying to get an access order, and so that one sounds like quite a bit of a nightmare, honestly, on both sides. It's been a real challenge. Ones that I've been involved with, it seems to be when the children are quite young, the ones I've been involved with, and that makes it really difficult for a grandparent to establish that they have a meaningful relationship with the child. And it's not just about, there has to be some kind of a relationship in order to force a parent of the child to, allow their child to go and have parenting time with a grandparent. So in my experience, it can be a tough uphill battle if the grandparent hasn't already been actively involved in the child's life. I don't know, what about you, Riley?
Yeah, I've handled a few, and under the provincial legislation, so the Family Law Act, leave is required to pursue a contact application unless the relationship that a grandparent had with their grandchild was disrupted because of the death of one of the parents. So sometimes we see those because it does allow that kind of immediate application to be made. And those, they're just very sad. Somebody has passed away. They're very difficult. Oftentimes, a grandparent, and the Divorce Act, the Amended Divorce Act says this: if a grandparent can exercise contact with the child during one of the parents' parenting time, it would not be anticipated that they get extra time or separate time, right? And so if, for example, it's the maternal grandparent, if they have a good relationship with the mother, they could have parenting time during the mother's or contact during the mother's parenting time. And it's not uncommon, that a grandparent might not have a great relationship with their own child for any reason, but might have a perfectly fine relationship with the other spouse and have contact during that parent's parenting time. I've seen that play out in a previous case. But there are also times when both parents have said, we do not want our child to have contact with grandparents for a good reason. And, the court will say, yep, those are some good reasons there. There's something that, has not been great in the past, or, there's sometimes grandparents can get quite invested in their children's conflict. And so sometimes can, feed into that or might not always behave as appropriately as we might hope. So they are very fact specific. Families are always unique and complex. And I feel like when grandparents are involved, it's just kind of like that next added level to that. But then there are also times when, you have an appropriate, loving, wonderful grandparent that for whatever reason is not permitted to have contact with the grandchild anymore. And it's clearly in the grandchild's best interest for that relationship to be preserved. So yeah, just so fact specific.
I think sometimes what comes across to me is this kind of train of thought. So the grandparent sees the parent as their child, right? Or their child's spouse, whatever. And they may still have that in their mind, view that person as their child or someone that is irresponsible, what have you. And therefore think that they really need to be involved in the child's life because, they are the only responsible one in the picture. And normally I think the parent does not see it that way at all. And I think it can be sometimes difficult for a grandparent to remember or difficult for them to put themselves in the parent's shoes. It's the state, rightly so, does not take lightly taking a child out of its parent's care. And so I think sometimes from the grandparent's perspective, because it's kind of a unique situation where they have a unique relationship with the parent, it can be easy for them to lose sight of that. Hey, we don't want the government to be able to just order the children out of a parent's care. We don't want the government to have that power. We want the parents to be responsible for the children. And if you ask the grandparent if they would be excited about the government telling them what to do with their children back when they were younger, I don't think they would be excited about that prospect either. So it's one of those things where I think it's right that the court is slow to make that type of an order against the will of one or both parents. But sometimes the parent really isn't in a position where they really do need the help of the grandparent, even if they don't have a good relationship with the grandparent. So that's my kind of take on it.
Would for family situation, extended families that are having that kind of struggle, would they also have access to the alternative dispute resolution tools, I guess, that are available to them?
Yes, absolutely. And would the same requirements to recommend that type of option, if it's appropriate in the first place, would apply to that type of application as well. And there would be nothing stopping, an extended family situation from accessing any of those same alternate dispute resolution options.
Okay.
So Riley, is there any changes that we haven't gone over yet?
No, I mean, there are certainly other changes, but that touches on all of the major changes that I was hoping to get through this afternoon.
Nice. We've been going for a while. I don't know how long we've been going for. Kim, do you see like a timer?
I do not see a timer.
Yeah, we've been going. I think we've been going for about an hour, and I think we've covered a lot and gotten some great insight about the changes, Riley. So thank you so much for coming and for sharing your thoughts and just educating us about these changes. They're still relatively new. Heather, do you have any last thoughts?
Thank you so much for your generous time, Riley, and for coming to be our guest. It was lovely to see you.
Yeah, and good job, Heather, on you performed marvelously. Maybe a little bit like the Michael Jordan fever performance. Oh, you're not familiar with that? Well,
I don't know.
In the finals against the Utah Jazz, had he alleges it was food poisoning. They ordered pizza, and they found out it was Michael Jordan, so they purposely poisoned the pizza on him because they were in Utah. He was really sick, and then he went out and had one of the best games of his playoffs in his career while he was puking moments before. So all-star performance, Heather.
Okay, thanks.
Kim, any last thoughts?
No, I think it's really interesting to learn about the key items that people can hone in on when they're thinking about the new or the amended Divorce Act. And I think this conversation today has also made it clear for people who aren't that up to date on legislation that there is a federal Divorce Act, and there's also a provincial document that all works together. And there's a lot to know, and that's why people engage with lawyers, because this stuff can be interpreted, as mentioned, in different ways, and the average person may not have the inclination, but they probably just don't have the time to really understand all this. So I appreciate the summary of the important bits and you taking the time to give that to us, Riley. Also good to see your face, because the last time we chatted was on the phone. So
yes. Yeah, thank you all for inviting me. It was my pleasure to come speak with you all.
Yeah, well, great. Like I said, great to have you. And I'm glad to hear we covered everything you were wanting to cover. You can also share any concluding thought that you want, if you have any for us.
No, I don't. I was gonna say something like pandemic specific, but that's just a little bit too depressing. So I'll just, no, I won't.
Okay, well, that'll do. So I also don't have a closing thought this time, but just thanks again, Riley, and this has been Access to Justice, and we'll see you next time.
Any information in this video is general information only and is not, nor is it intended to be, legal advice. Watching this video does not create a lawyer-client relationship. You should always seek the advice of a lawyer or other qualified professional for advice regarding your individual situation. While we take care to ensure that the information contained in this video is accurate and up to date, we make no warranties or representations as to the suitability, completeness, or accuracy of the information contained in this video. Any reliance you place on the information is at your own risk. Kahane Law Office, Merrick Law, Heather Malarick Professional Corporation, Evan Clark Professional Corporation, Evan Clark, Heather Malarick, and any guests will not be responsible nor liable in any way for any content, including but not limited to any errors or omissions in the content, or for any loss or damage of any kind incurred as a result of any content communicated in this video, whether by Evan Clark, Heather Malarick, or by a third party. Kim Mcdonald is a financial advisor with Raymond James Limited. Information provided is not a solicitation, and although obtained from sources considered reliable, is not guaranteed. The view and opinions contained in this media are those of Kim Mcdonald, not Raymond James Limited. Securities-related products and services are offered through Raymond James Limited, member Canadian Investor Protection Fund. Insurance products and services are offered through Raymond James Financial Planning Limited, which is not a member Canadian Investor Protection Fund. Raymond James advisors are not tax advisors, and we recommend that clients seek independent advice from a professional advisor on tax-related matters. Insurance products and services are offered through Raymond James Financial Planning Limited, RJFP, a subsidiary of Raymond James Limited, which is not a member Canadian Investor Protection Fund. When providing life insurance products, financial advisors are acting as insurance representatives of RJFP.
Darkness of the dales dissipates, declines, because of he who turns